You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
No, it's good to see you again, David. And,
it's good to see you again.
Well, you know, I'm kind of struggling a little bit with my quarantine hair here. It's getting a little unruly, but I had an appointment to go get my hair cut, and then I got this email, hey, you got to wear a mask, and I'm sorry. Like, I know there's a lot of different opinions out there, but I cannot subscribe to this new mask wearing society we have. I don't know if you remember the Flowbee, that you had a vacuum cleaner kind of like sucked and cut your hair at the same time?
I think there was a Revco product or something. I don't know, but anyway.
I will Flowbee my hair before I wear a mask, go get a haircut. That's just me. Anyway.
Well, it hides your wonderful beard, see.
It just kind of runs together.
Yeah.
Well, I wanted to start today with, we did a dumb tweet of the week at one point. This is a really great tweet of the week. Quite the opposite. I don't know if I bet you've probably never heard of Zuby.
No.
I'm just guessing.
Probably some kind of new app, I guess, right?
So Zuby is he's actually a rapper in England, and he comes across I think I started following him at some point or whatever, but he comes across my Twitter feed because a lot of conservatives that I follow retweet him or like his tweets or whatever. And this really great tweet this week, I thought it was so pertinent to what some things we've said in the past and also sort of what we're going to talk about today. He says, the biggest weakness of conservatives is that they always allow progressives to control the language. Lefties are always introducing new words and redefining old ones. Once you cede linguistic territory, it's just a matter of time until you cede ideological territory. Well, that was a great statement.
Boy.
Go Zuby.
Really is. And, that's exactly what we were talking about last week, that words are power. When you can redefine the words or define the words for a culture, you are the master of it. And so today we're going to be talking about words and how do we understand and define words. And some of what's going on, I hate to say, even in our own state now. I'm not talking about globally or in some kind of human rights court internationally. I'm talking about here in the Tennessee courts.
Yeah. So I guess there was a case happened last week, Pippin versus Pippin, and we're gonna get into that. Of course, regarding Obergefell v. Hodges, which we seem to talk about a lot, but it's in the courts a lot.
Yeah.
As it was last week.
Those who think that case, Obergefell v. Hodges, just was about same-sex marriage, and they don't care. They don't understand what it said and how it's being received by judges. And that's what was in front of the Court of Appeals in Tennessee just last week, is how does Obergefell apply to new situations right here in the state of Tennessee and how we interpret our laws.
I've heard you say in the past that, and especially pertaining to Roe v. Wade and also the Obergefell Hodges, in some of these decisions, there is a diseased root, and that root left to germinate and grow rears its face in all sorts of things, way beyond, like Roe v. Wade does not just impact abortion and how it's and how it makes its way through the courts. And Obergefell v. Hodges doesn't just affect marriage. It affects a whole host of things on how the court, as we'll see here, treats words and its authority versus federal authority and state statutes. And you'll get into a bunch of things here, but it affects quite a bit of our life as it takes hold in various areas of the court.
Yeah, it does. And really, from a Christian perspective, it has to. Because God created a unified universe. So when you begin to play with what evolutionists would call Mother Nature, when you begin to say, we get to make up our own rules, then you have to make up all the rules for the new cosmos you've created. You can't just make up part of it. You have to figure out, having now done this, how do I now do this? And that's what courts do. They look at, well, what did we decide here? And now how do I apply that here? And that's what happened last week in this Pippin case.
Let's dig into that a little bit. So tell us what happened.
Yeah. Well, the Pippin case involved two women who entered into a relationship prior to the Obergefell decision. So in Tennessee, they could not legally go down and get a marriage license and to get married. But they did a little ceremony. They exchanged rings. They referred to themselves in a marital context. This is my wife and this is my wife. Then before Obergefell, they had a child. One of them went and got artificially inseminated. They both went down and looked at donor profiles and decided to have a child. They told the child, who's now several years old, that they were the child's mother. They treated themselves as parents. Everybody called them as parents. Everything was done as if they were a man and a woman and were married. Then Obergefell comes along. Well, actually, they break up in 2014. They wind up getting back together. Obergefell comes out. About a year later, they break up again. And now the non-biological woman who was in the partnership, spousal relationship, she has no legal interest in this child. I mean, she never adopted the child. She wasn't married at the time they inseminated, and they never got married. So she's, in a sense, in relationship to that child, no different than a grandparent or an aunt or an uncle or anybody else, maybe closer in love or affection, but she's a biological stranger. So she goes into court and says, I have to have parental rights. She said, I am a de facto, meaning as a matter of fact. No, we're not really, but as a matter of fact, I'm a parent. And because of the Obergefell decision, you have to treat me as a parent. Now that's what the case was about. Two of the judges, Judges Dinkins and McBrayer, ruled that, I'm sorry, the statutes do not cover you. Your situation is foreign to the law of the state of Tennessee. There are no such things as de facto parents. There are step-parents, there are biological parents, there are adoptive parents, potential adoptive parents. The statutes give rights to all of them. There are grandparent visitation rights, but the legislature's never created a de facto, you're fulfilling functions like a parent, so you're a parent statute. So Judge Dinkins and McBrayer rejected the claim and said, if the legislature wants to do something about it, they can. Judge Andy Bennett, who I know, who worked for years as the right-hand person for the state attorney general's office, filed a dissenting opinion and said, no, we have to change how we would do this because of Obergefell. So that's the context of the issue.
And it's also worth clarifying a point. It's worth noting as we dig into this issue that according to Tennessee law, even in regards to men and women, in Tennessee, you have to be licensed to be married. In other words, Tennessee will not recognize all sorts of rights if you don't, no matter if you're a man or a woman and you've been domiciled together for 10 years, if you don't have a marriage license. And it's worth pointing out that after 2015, these women never came back to be married or get a license or any of that. So
That's right.
The law would apply the same to men and women or in this situation.
That's right. In fact, there's a case that came out of the federal district court in Nashville by the same judge that handled essentially the Obergefell type case against Tennessee back in 2015. And what had happened here is this man and woman had exchanged vows in front of the preachers, held themselves out to be married to everybody, were in that state for a number of years. He got injured and sued, and she filed a claim for loss of consortium, that I've lost, in essence, a part of my relationship with my husband. And the judge said, sweetie, I know y'all thought you were married, and I know you thought, according to your religious belief, you didn't have to have a license. But in Tennessee, if you don't have a license, you're not married, and you have no claim.
Wow.
She lost the ability to even file a lawsuit to recover the damages for the injury to the relationship between she and this man.
Wow.
So the law's very clear there. We don't have any kind of common law marriage or shack-up marriage or a Lee Marvin partnership thing. You're married or you're not. You have a license or you're not. That's it. So that's the situation. Now, here's what the lady went in and claimed. She said, well, there is a statute on the books that says when a married woman with the consent of her husband has a child by insemination, the child shall be regarded as that of the husband and wife. And she said, that statute applies to me to make me a parent. Now think about the words you just heard. When a married woman, so you have to be married, with the consent of her husband, sounds like a man, then the child is that of the husband and wife, sounds like a man and a woman.
Mm-hmm.
She said, because of the Obergefell decision, you have to re-understand and reinterpret all of your statutes, and that should apply to me. Now, what's interesting, to me, it's very interesting, she used the position taken by the Tennessee Attorney General in a lawsuit in which I represented 73 of the 132 members of the General Assembly. And the Attorney General, in a case involving two married women, said, oh, Your Honor, you have to, because of Obergefell, reinterpret the word husband to just mean spouse. And so as long as you're married, both of them are parents and there's a birth certificate and they both go on the birth certificate as mothers. And he used a statute to argue this. This is fascinating. Passed in 1851. Now, this is how long this statute's been on the book. And it's in the section saying, how do we interpret the statutes? So there are lots of little provisions in there. Like, does the heading or the title of the statute, is that part of the law or not part of the law? And this one deals with grammatical constructions. Do we mean singular or plural? And if we say man, is that really referring to mankind or is that referring to a man? And it deals with gender. And it says, now this is from 1851, words importing the masculine gender shall include the feminine and neuter when it's not contrary to the clear intent of the statute. Now, why was that passed in 1851? Because oftentimes we just use the word he or his or her or him.
Yeah, words like mankind.
His. Yeah, and we didn't go him or her, he or she, any of that stuff. We just, and so unless we're clearly not talking about a man, then you can include the feminine and the neuter. Well, neuter means it's not either masculine or feminine in its grammatical construction. Now, the Attorney General argued in this divorce case in Knoxville that, you apply that to the word husband, so that husband can include the feminine. It could mean a wife and a wife. Okay? And the court bought that argument. Originally, the court in Knoxville rejected that argument. So I can do that. But when the Attorney General made the argument, he agreed to it. So she makes the same argument. You have to not entreat the word husband to really mean husband. And in fact, she's arguing, you don't even really have to treat us you need to treat us as de facto married because we thought we were married. Now, Judge Dinkins and Judge McBrayer in the majority said, we can't do that. The word married means married. You're not married. And the words husband clearly have a biological meaning here. This is not just a matter of correspondence between nouns and pronouns. So they rejected that.
It was clear. It was clear what the legislature intended when they used the words man and woman. Yeah. Yeah,
married, a husband and a wife. Yeah, they knew what they meant. So then she says, well, okay, if you don't believe that, there is a parentage statute, which is what we use for men to prove, or a woman to prove, who the biological father is. So if you have a child out of wedlock and the woman won't let you see the child, the man can go in and prove, I am the biological father of this child. Or the woman, if she wants child support, she can go in and say, no, David is the biological father of this child, and she can prove it, and the court would determine whether or not that is my child. Now, you might say, well, that couldn't apply to two women. And the answer is, you're right, it couldn't. In fact, the statute there, dealing with parentage and proving paternity, I mean, that's what we're proving, paternity. That sounds like paternal. That sounds like man, father, okay, not mother. And the statute specifically talks about a father of a child. When the man receives the child into the home, those are the kinds of words that are used. It defines the parent as the biological mother or the biological father of the child. So we're clearly talking here about biological connection to the child at issue.
Yeah.
And she argued, well, because of Obergefell, you can't interpret those words that way, and you need to use that gender-neutral statute to redefine what a biological father is and a biological mother is. Thankfully, McBrayer and Dinkins said, we can't do that. The legislature's clear what it intended. Now, they said one other thing that's very, very important. They said, we can't interpret a statute to extend its meaning when the words are clear and we know what they are.
Right.
We can't use the statute to extend its meaning beyond what the legislature intended.
Yeah, if you know what the words mean and the statute needs to mean something else, then that's got to go back to the legislature and let them redefine what that statute needs to be, not the court.
That's right. That's right. And the court pointed out, they've done this for adoptive parents and step parents and inseminated parents that are married. They've done this for embryo donations. They've done it for step parents. They haven't done it in a situation like yours. And because you're not a biological parent, you can't prove parentage. You could only be a parent as a matter of law, a law-given status. You don't have any biological status, and the legislature's never done that. So if we rewrite these words to mean what they clearly don't mean, and they're not ambiguous, we've extended the law, and only the legislature can extend the law. I think that's a great conclusion. Now, before we get to the dissent, which flabbergasts me, Judge Dinkins and Judge McBrayer are two judges on the panel that 3 years ago dismissed the lawsuit brought by ministers and citizens that we handled, saying, after Obergefell, we're not sure if our marriage statutes are still valid because a clerk can only issue a marriage license to a, quote, male and female contracting party. Now, that would seem to mean that you have to have a biological person with a certain anatomical structure and reproductive system and one of the opposite kind. And the court said, well, the Supreme Court said we can't do that, so we're just going to ignore those words. So the two judges that just said we can't expand a statute beyond what the legislature intended. We can't reinterpret words like man and father and husband and biological differently than what they are, ignored the words male and female.
Are doing it in another sense. Yeah.
Yeah. Now, what they'll say is, well, Obergefell specifically applies to marriage, and it doesn't have to apply in this situation.
Into the parenting context, yeah.
But here's the point. The issue here isn't whether this is marriage or just two lesbians who aren't married. The question is, what is the authority and power of courts to interpret words in statutes that are not ambiguous and unclear? That's the question.
Right.
You can't say, well, in certain kinds of cases, we're going to pretend the words are ambiguous and unclear, and we're going to rewrite the statute and expand the scope of authority. But over in these cases, no, we don't have the power to do that.
Well, and like
they either do or they don't.
And like you put in your letter here, it's also an issue of do states have the power to interpret their own statutes? Or does the federal government have the authority to come in and reinterpret our state statutes?
Yeah. So with that, that's a great segue to the dissenting opinion of Judge Bennett. Now, I'm going to read you the first two sentences. This opinion, referring to that of Justice McBrayer and Dinkins, who wrote the majority, came to a correct analysis, stayed within their lane as judges, didn't rewrite the law, didn't rewrite the words, didn't expand the authority of anybody to do anything. He said, this opinion is stuck in the past. In my opinion, Obergefell versus Hodges altered the way we must interpret many statutes relating to marriage and parentage. Now, on its face, you might say, yeah, I guess so. But think about what he's saying here. He said the United States Supreme Court, a branch of the federal government, has the power to tell Tennessee how Tennessee judges, whose power comes from the Tennessee Constitution, from the people of Tennessee, how they must interpret their own statutes. Now, since when do federal judges change the power of state courts to interpret state laws?
Which is explicitly a violation of the separation of powers.
Absolutely. And a principle of federalism.
And federalism.
Federal court, yeah,
right.
Yeah. I mean, I've got plenty of cases that I've cited in my marriage cases where the Supreme Court has said, our interpretation of state law is not binding on state courts.
Yeah, I've seen that written down, in several opinions.
Yeah. And a lot of times when it's now sometimes, it's not to say that federal courts never interpret a state statute, but usually they only do it when there are enough cases to make it clear to the federal court how the state court would interpret the law. Okay, they don't just go out here and decide willy-nilly, this is how we're going to interpret it. And in fact, if it's a case of first impression, meaning a case that, wow, we've never thought about this issue before, the federal courts will certify it to the state Supreme Court and say, I don't know how to interpret this. And if you'll interpret it for me, then I'll decide if it's constitutional. But I don't want to decide it's unconstitutional and then have you tell me, well, that's not how the statute's supposed to be interpreted. So understand what Judge Bennett is saying. The United States Supreme Court changes and can tell state courts how to interpret state laws. That's
big.
That is an unfathomable statement, in my opinion. And I know the judge. He's a fine man. He's a morally upright man, as far as I know. He's a person of, as far as I know, moral integrity. He's not stupid. I'm not saying any of those things about the judge. But his judicial philosophy is not in accord with the principles of separation of powers and the principles of federalism. It's just not.
Well, he also believes clearly that courts make laws.
And they do sort of, and you'll hear that phrase. I might even use that phrase sometimes. But what they do is they make the law as between the parties.
Right.
They don't make the law for the whole people.
They make the law within the confines of that case or controversy, not for the whole of the people.
That's right. And so he's trying to say, we're going to reinterpret this law, and then here's what will happen. If he had won, if he had been on the majority, other courts of appeals would have looked to that and said, well, I guess we should follow that. Every trial court in the Middle District of Tennessee would say, that's how I must now interpret the statute. And off we'd go with two people who are not married being treated as if they're married. And the words male and female and husband and wife and biological father and biological spouse and married all now mean something different than what anybody thought when the legislature used those words in statutes decades ago.
It doesn't matter anymore.
That's Zobe right there. That's Zobe. That's what he was saying. That's what Humpty Dumpty was saying. Words mean what I say they mean, and the issue is who shall be master.
Yeah, who's in control.
That's right. And so if I'm a legislator, which I was for 12 years, I now want to pass a statute that applies to men. What word can I use that a court with this judicial philosophy could not rewrite to say, well, man didn't mean man? I mean, we're talking about a statute here that refers to a father as the biological. Now, that's pretty clear to me. Biology is intended here. Oh, what they're going to disregard that too. Do you see the problem in our court system? And do you see what happens if that becomes the majority opinion and legislators adopt judicial supremacy? They'll say, well, I guess that's what the law is.
Right.
And I don't blame them, because if the word biological father doesn't mean a male who got a woman pregnant and produced the child, I don't know as a legislator what word I do use in the future if I even wanted to amend the statute.
That's a great point.
What word do I use now?
Yeah.
Truly biological.
Cis male.
I don't know. So Judge Bennett was willing to say, even though you don't have a license, and even though the Attorney General's office that I've worked for, his name may even be on opinions or may be behind opinions of the Attorney General's office that said, if you don't have a license, you're not married. I don't care what you are.
That's the thing that's sort of the thing that gets me about this case, that if in this instance a man and a woman came to the court with this all things considered equal, it would be clear to the court, well, you're not married, you don't have a license, and you can't be the parent or whatever.
Yeah, that's right. And so he's saying Obergefell changed the way state courts have to interpret state law. See, that's where he gets it. Well, somehow the Supreme Court decision in a case about marriage now changes the way I have to look at everything that looks and smells and feels like a marriage, even if by state law it's not a marriage. We treat it as a marriage. Now, if I'm a legislator, what word do I now use for marriage to mean you really do have a license? Do I amend the state statute to say you're only married if you have a license, and we really mean a license, which is a piece of paper that has the words biological? What word do I use to mean married anymore?
Well, another thing, kind of going along with what you're saying, and I mean, we've talked about the idea that, you know, federal court really doesn't interpret state statutes for the state court. They usually leave that to the state court. It's kind of one issue. There was another thing that stood out to me in Bennett's dissent, which is confusing. It's on the issue of standing, which in one point he acknowledges that courts look at someone who is injured. In other words, if a court is going to take up an issue, they look at someone that's injured. He says a standing is a judicial doctrine used to determine whether a party is entitled to have a court decide the merits of the dispute. The doctrine of standing precludes courts from adjudicating an action at the instance of one whose rights have not been invaded or infringed. More specifically, this doctrine, and I highlighted this part, restricts the exercise of judicial power to litigants who can show injury in fact. And it just got me that he would say that, because he's communicating to me by reading this that, you know, yes, courts are limited to people who are injured, to cases and controversies. Yet in the same breath, just a couple paragraphs down, he's willing to say that the federal court, the Obergefell v. Hodges cases, created a new law and affected the whole of the people, regardless of whether or not there was an injury outside of cases or controversy. It's just a blanket, you know, kind of ruling that, you know what I'm saying? Those two,
as long as you're a homosexual, you have standing.
Right.
Almost.
Yeah. Exactly. But
now, if you're a preacher in my lawsuit,
right, you didn't get
or a
that
citizen
treatment in your lawsuit.
I don't have. Yeah, I'm trying to figure out what Obergefell means, and my ministers actually have to administer the license statute. They actually have to administer it. They're designated by law,
right,
to be people who solemnize and who must have a license. And if they don't return that license within 30 days or whatever it is after the marriage, then they're subject to a misdemeanor and a fine. And if they don't have a license, the couple can sue them for damages, for, you know, pretend it's like Catch Me If You Can. I'm sorry, I really wasn't a minister. Well, I can sue you. Or I didn't really have a license. I can sue you.
So that's
and I don't have standing, but you know, if you're a gay couple,
but every homosexual has standing.
Yes.
See, those two things are incongruent to me.
Sure. No, they are incongruent. Now, the majority did get it right. Dinkins and McBrayer got it right in this case. They said, well, when you read the statutes, you're not in them. You're not married. You're not a man. You're not a biological father. So you don't have any standing to complain about it. That would be like, Gary, you going down and saying, I'm interested if the marriage licensing statute is still valid. And they say, well, are you a minister or a county or a city official that can perform marriages? No, but I think this is a really interesting legal question. And I really like marriages, and I go to marriages, and I've got some friends that are getting married. And they'd say, well, you don't come under the statute of people who are involved in the marriage process. You can't sue. And that's what the majority was saying. And that's what Bennett was saying. Well, it really doesn't matter. And all I want in my cases is the equal treatment of the law. Apply the same interpretive principles. Don't apply them differently if it's a marriage license versus a parenting statute or a birth certificate. The power to interpret is the power to interpret. The Supreme Court does not change the power of state courts to interpret state statutes. Justice Bennett thinks they do. Great, more power to him. But when you say we reject Judge Bennett's idea that Obergefell changes the power of courts to interpret state laws, then why did we not apply the same idea in the lawsuit I filed? I don't get it. But there's where we are in the judicial branch. And if people don't get that, in fact, I'll just put a plug for today's commentary. It has to do with judicial supremacy. And maybe we should close on this, but we're changing the way we're doing voter guides this year. Because so much of the policy decisions that are made by legislators are framed or understood or evaluated in the context of what they believe about the nature of the judicial power and what courts do.
It's not anymore. It's not just whether or not did you vote for this bill or did you vote for that bill. It's like, what do you believe about? Do you believe in federalism? Do you believe that courts
believe in separation of powers? Yeah. Do you believe in these things? Yeah. So if you say you do, then are you going to actually apply them in this case? Oh, well, no, I'm not. Well, why? I mean, so people want to know more about this really ought to read today's commentary. But I thought people need to understand the battle that's taking place in the courts, the idea that there are many judges who believe it's our job to reinterpret statutes in order to make them constitutional as we understand the constitutional. And that's not left up to the legislature. My view, if I were a judge, is if the statute's unconstitutional, it's not my job to rewrite it. I'm going to say the statute's unconstitutional, and you legislators go figure out how to rewrite it.
Your job to fix it.
It's not my job to rewrite it.
Right.
That's right. It's not my job. It's outside my power. So that's the topic for today. This is important stuff.
And I just would like to point out yet again this issue of where so many, I've read past articles and whatever, how, David Fowler is he's just crazy guy. This is never going to affect parenting. He's just a fear monger and making everybody scared. And here we are yet again. The court is directly looking at a parentage case and bringing in, albeit involving a homosexual couple, but nonetheless bringing up Obergefell v. Hodges to determine an issue of parentage. And this is going to impact, again, like this diseased root. If it's not chopped off at the root, it will eventually have a very decisive impact on family policy, just in general, if we keep letting this thing grow and grow and grow and grow. And anyway, I just wanted to point out that little fact again.
And we need to stop, but you may be sitting here saying, well, I'm a biological parent and that doesn't matter.
Doesn't matter. Yeah, exactly.
But let me tell you why it does. Because if that principle in Obergefell, we have to treat everything equal, is now going to be applied outside who can get a license, then eventually we're going to have biological parents who are going to assert that I have certain natural, God-given, common law rights in the nurturing and instruction and raising of my children by virtue of biology.
Not according to the doctrine of equal dignity, you don't. Not if this equal dignity stuff keeps promulgating
right.
all
So
throughout.
so over here in the situation that we were talking about in Pippin, that woman would become a parent by law. She would have no natural, God-given, common law, parental rights or relationships. So where one married couple, let's say, gets their parenting rights by law, the other gets them by nature, how are you going to make them equal unless, because I can never make you a biological parent that you're not biological, is I make biology, natural parentage irrelevant.
Yeah.
And all
we have to
rights.
do away with biology and now do everything by positive law.
Yeah. And if you don't think that's real, there are law review articles I can send you from Richard Legame and others in the Harvard Law Review where they're saying now even parentage has to be redefined in terms of what services and functions does a person carry out in a child's life. Just telling you. There it is.
Important stuff.
Yeah.
Well, thanks again. We appreciate you guys joining us again for this episode of God, Law, and
Sure
Liberty.
do.
As always, you can email us at info@factn.org, info@factn.org. We'd love to hear your questions, comments, concerns, and we'd love to answer those for you. Thanks for tuning in, and we'll see you next time.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.